Good afternoon, members. Thank you for joining us today for the Flipper Lunchbox seminar. If you have any difficulties hearing us or seeing us, if you wish to see us, let us know through the question box that's at the bottom of your screen. Today, we are fortunate to have Mr. Leigh McBean of RateSetter Australia speak to us about our solicitor's duties and the family law rules when running interim applications for partial property distributions in order to obtain funds. And Leigh is going to compare and contrast those applications with the alternative of borrowing. Leigh has an extensive history in working in and around family law, beginning in March 2008 when he commenced his employment at Jones Mitchell Lawyers as a family law specialist. In February 2018, Leigh became the head of legal finance at RateSetter Australia. And if you aren't already familiar with RateSetter, Leigh will introduce you today, I'm sure. Today is going to be an interactive session, so if you have any questions throughout, again, just put them in the question box and we can answer them as we go. All right, thank you, Leigh.
Thank you, Sky. Hello, everybody. Thanks for joining us today. Slides not.
Yeah, just click on. Okay. Yeah, let's try that. There's your mouse. So, there's your mouse. There you go. Is that working?
There we go. Thank you very much, Caroline. So thanks for the nice introduction, Sky. Today I'll talk to you a little bit about, as Sky mentioned, family law rules in respect to running interim applications for part property distribution, compare and contrast that to the legal loan that we provide, and why in particular borrowing may actually be in your and your client's best interests. I have at the back end of the slides, which I'm happy to email, Sky, if you email that out through to everybody afterwards, things around our lending criteria, how the loan works, and some of the ways in which we operate. But I'm happy to not talk about them today, given that it is about professional conduct and ethics. But it's there if anyone has any questions, and particularly to refer back to afterwards in the written form. Certainly encourage you to ask me any questions as we go. I certainly would like this to be interactive rather than me talking just to you. So happy to entertain questions. About us, just at a high level before I start, RateSetter Australia is a nationwide service. We're a peer-to-peer financial marketplace. Just like I could borrow, so just like I could buy something from you directly through eBay, RateSetter creates a marketplace where I could borrow money directly from you through the marketplace of RateSetter. So we are a place where people can both borrow money and also invest. On the borrowing side, last month we passed $500 million of consumer loans made, and we engage in what's known as risk-based pricing. So we price risk based on individual circumstances rather than a standard rate of risk or a standard interest rate, depending on if you went to the bank today and got a home loan or a credit card, everyone's got the same price. We engage in individual pricing based on your circumstances. On the investing side, we source money from self-managed super funds, mums and dads, students, individuals, anything from $10 upwards. And individuals set the rate they want to return. They want to earn, I should say. So people are earning between 20% return on the investing side. And we then match you directly with borrowers priced at different levels. So if people want to have a higher rate of return, we'll match you with higher risk borrowers. And if people want a safer, lower return, we match you with lower risk borrowers. So that's what we do as a business. There's 5 lending arms. The most important one is the bottom bullet point there at point 5, which is relevant for you, which is the function I lead, which is legal finance. But we have a number of other lending arms, one of which really interestingly is a renewables energy market, where we've just announced a $100 million partnership with the South Australian Government and the Clean Energy Finance Corporation to put home batteries on people's homes in South Australia to combat their electricity supply issues. The state keeps going black and running out of power, hence the whole Tesla proposal last year. The reason I mention that is around credibility. I'm very conscious that there were a number of lenders in the market in family law about 10 years ago. Quantum, Impact, Ask and Guardian all existed in the market and fell over. So what as we go through this presentation, and certainly I'll be at the Noosa Flipper retreat, so please come and talk to me in more detail up there, is about building trust and credibility within the legal profession and overcoming some of the problems that the previous funders incurred or encountered. And I certainly run things very differently to them. So as a business, I mentioned in particular the government endorsement through South Australia for our renewables market and the Clean Energy Finance Corporation and what we're doing there with government in other states. So legal finance, before I start on the solicitor's duties and the ethics, we have over 100 law firm relationships nationally now. Former lawyer at Jones Mitchell, hold an MBA and a law degree and a commerce degree. I used to teach, interestingly, in legal ethics to PLT students on this subject, or one of these subjects in particular, and other law subjects at university level, so something quite dear to my heart. And I've been there looking after legal finance function for 18 months. As a business, we're receiving about 25 to 30 applications a month from clients across Australia. I'm approving about 60% of those, which means we're approving about $1 to $1.5 million in credit each month, and we're sending out the door about $1 million a month to lawyers across the country to pay invoices, to pay disbursements, to pay counsel's fees, to pay all things in relation to pay valuers, forensic accountants, all things connected to the family law matter. So we're sending out the door about $1 million a month, and it's growing each month. We've approved about 148 matters, most of them in the last 18 months. Right now, I've got 98 open loans on the book and 0 defaults so far. And we're not a litigation funder. So I say all of that just to establish some context for you. So why am I listening to this person about legal ethics and in particular interim applications for part distribution versus a loan that we provide? So as part of professional development today, I want to help introduce you to some new concepts that might help you with your practice, help improve the quality of the advice you give your clients, increase your and your clients' options, promote the best interest of the client, question the status quo and the way in which things are done, typically around the paying of fees and the meeting of costs, and ask if we are meeting the current thresholds and the duties to the court. I am most busy out of Sydney and Melbourne. Queensland is disproportionately slower in that respect, and also probably more conservative in my experience so far, particularly with my engagements in Sydney and Melbourne firms. Less litigious, but also for matters that don't necessarily require court or litigation. There's still a lot of need to meet cost, and 70% of our borrowers we're finding are women, month on, month out, and the majority of them stay-at-home mums. And so as a group of people who need to be able to pay fees but don't have an access to an income, they are a group of people who, litigation or otherwise, still struggle to pay the bills. And for which matters running an interim application for part property is probably not that cost sensible at the same time, or proportionate to the size of the pool. So I think Queensland's slowness in that respect to take up the matters might be legacy, in the sense that there were a lot of guardian and impact and ask matters struggled here 10 years ago or went south, and I've got to deal with the consequences, I think, of that legacy perception, rightly or wrongly. So bit by bit, I try to break that down and educate around how we're different. That's not what I'm doing today, though. I'll talk about something else, but I'm more than happy at any point in time to engage in a conversation around how we work and how we support your clients to pay your fees. On family law rules and precedents, Rule 104, the main purpose of family law rules is to ensure that each case is resolved in a just and timely manner to the parties and to the court. It's going to be a bit of a central theme to the next couple of slides, is that public purse and public policy aspect. Rule 106, the courts to manage each case by sub-rule G, considering whether likely benefits of taking a step justify the cost of that step, and sub-rule I, minimising the need of the parties to attend court in the first place. Rule 107, the courts apply the family law rules in a way that promotes the savings of costs and gives an appropriate share of the court's resources to a case, taking into account the needs of other cases. And Rule 108, responsibility on us as lawyers are to ensure that any orders we seek are reasonable and that we manage matters in a cost-effective way. So there's a bit of a theme when you look through the family law rules and also the pre-action procedures that talk about at Rule 16H, the parties must have regard to the principle of proportionality and again, the need to control cost. And 6.1, lawyers' obligations, the very first paragraph on that subparagraph, the very first subparagraph is the obligations are to advise clients of ways of resolving a dispute without starting legal action if you can. And so I say all of those things in context of running interim applications for part property, but also the overarching obligation on lawyers to consider the cost to the court, to the client, and essentially to the public purse in the conduct of every matter that you run, not just ones that involve interim applications. So as officers of the court, we're duty bound to consider ways to minimise cost to the public system. Court backlog and delays that everyone's experiencing right now, and frustratingly so, are not in the client's best interests and do not provide an efficient administration of justice. Hence I will talk about reform one way or the other. As lawyers, we're obliged to look after the best interests of the client, and we therefore need to explore ways to look at cost reduction, improving access to justice and advance the interests of our clients. And that comes under a number of different banners: legally, under the family law rules that we just covered, ethically as practitioners charged under solicitors' duties, and morally as taxpayers who we contribute to the public purse. Funds need to be distributed across the healthcare system, education department, roads, the court system. Legal ethics and social ethics are connected, and the legal system operates within society, so we don't operate in a bubble in that regard. When you look at the case law for interim applications, I'm sure you're all very familiar with Strahan case. Paragraph 114, their honours say it's preferable to only have one hearing on section 79 matters if you can. They don't want to be hearing interim applications for part property if it can be avoided. Paragraph 132, the first procedural step is it in the interests of justice, and is it in the circumstances it's appropriate that you ask the court to exercise their discretionary power. And at paragraph 133, they say that an inability to defray legal costs without which funds and injustice may be caused. So essentially, to summarise that, to satisfy the tests, we need to be able to say to the court that it is the last option. And if not for an exercise of judicial discretion to make an interim order for part property, that we're saying an injustice will be caused to our clients. So some questions that I ask and raise in the context of ethics and solicitors' obligations in light of the framework of Strahan and the obligations under us and the family law rules is, does a client have an inability to defray legal costs if another option exists, such as borrowing? Is it appropriate in all circumstances that you ask the court to make an order? And is it appropriate you go to court in the first place seeking such an order? And can you say in your affidavit that there will be an injustice to your client if all options have not been explored? They're good questions to ask as a solicitor before you commence an interim application. They're also good questions to ask in defence of an interim application. We're starting to see, particularly in Melbourne and Sydney now, more lawyers running the defence argument that says, well, we're premature going to court seeking interim orders if you haven't explored all other options. And different jurisdictions around the country are more or less strict on this topic. Some judges in some jurisdictions I'm finding are certainly stricter and will insist on seeing a rejection letter from us, for example, before they'll entertain an interim application for part property. Others are a bit looser in their rules. But I think as far as our obligations, they are consistent across the country. It's just the interpretation of them across jurisdictions that differ. And now that we exist as an option, you know, for the last 10 years where there hasn't been an option in the collapse of the previous funders 10 years ago, since then there's been a bit of a black hole, and it is probably appropriate to run to the court seeking interim application orders or part property orders. But now that a legitimate alternative exists, And I'm never one to tell any lawyer how to run their file and to run their case, and it's not in any way what we do. There's questions I ask around, can you say that in your affidavit material that injustice will flow, and can you ask the other side if they're premature in running a part property, if all options have not been explored. Comparing and contrast, let's focus on the left-hand column first. The direct costs of running an interim application are all things that you'll be familiar with. You can prepare the interim, you need the client affidavit, lawyer affidavit, the first return, the second return if you get bumped on the first return, your time to attend, counsel's cost and time to prepare and attend. You may incur your client $15,000, $20,000 potentially in those costs to be borne by your client, and you already need an application on foot to run an interim application. Not to mention your indirect costs where the outcome's not guaranteed. You've got the time taken to prepare file and wait for a decision, which we know is taking longer these days. The strain on the firm if you've been carrying clients. There's certainly disbursement pressure. It's one thing to carry a client. It's quite another to meet an outgoing for counsel who aren't happy always to defer fees. You're adding to the court backlog and cost the taxpayer. There's liquidity issues and liquidity risk if you can't point to a clear ability for the other side to meet or make a partial distribution to your client. And there's an additional piece of dispute and stress added to what is already generally protracted litigation and series of disputes. Comparing that to what we provide, say you're seeking $100,000 for your client in an interim application, and you alternatively could seek $100,000 from us, then the total cost of the client will be not more than $23,000 over 2 years. So we get to that's about 11.8% per annum cost of funds if the full $100,000 is borrowed. Certainly less than that if people draw down less. But as a max, as an example, it might be similar in cost than it would be to run the interim in the first place. Certainly quicker, 0.2, turnaround time for application received to dollars paid is 2 to 4 weeks. It's private, it removes the dispute and increases the focus and allows you to focus on the remaining issues that need resolving. Reduces cost to the public purse. If it meets lending principles, which I'm happy to chat about at a later point in time, it certainly gives you greater ability with your clients to give a greater level of certainty around their options. And if you're weighing up, if you could go to court, here's the risks. You could run an application to RateSetter in the first instance. It won't cost anything and certainly will provide greater levels of certainty to the client if approved. Or even if you know the criteria, you can with confidence say what may or may not be approved. Point 7, I've got a slide specifically on this later in the presentation, but you do reserve the right to argue the characterisation of the costs of the loan and therefore create greater leverage and flexibility in later negotiations. Not that you always care about the costs incurred to the other side, but not running an interim application does save the other side the cost of defending it. Certainly allowed at point 9 to be disbursements, fees and personal use, so it's greater scope than sometimes the court allows when running part property or interim costs orders. Certainly restricted more so in the use of that money, whereas we are a bit more liberal with how you are allowed to, or the client I should say, is allowed to use the funds. And if you went to us asking for $100,000, you don't have to pay $20,000 in legal fees to obtain that money. You've got the full access to it. So it's not eroded in any way. I raise these questions around the client's best interests, and except for in circumstances, and I imagine you might be thinking that, well, what if the loan size is not enough? What if I need more than that? So in circumstances where the loan size, and I'll talk about how much we offer later, well, let's say 400,000, we go from 25,000 to 400,000. So except in circumstances where $400,000 is not enough for the amount you're seeking for your client, particularly on big money matters, or at point B, the preservation of the property pool might be part of the outcome that you're seeking in your interim application, or the cost to run the interim application might be very simple and you might think it's cheaper than our loan, or point D, you're seeking other interim orders as well. You're seeking a parenting order or a lump sum spousal maintenance, for example, then it's absolutely right that you go to court seeking interim orders in those instances. But My question is, if those things aren't relevant and you're just simply going to court asking for funds, my question would be, why would you run an interim application when a legal loan generally is cheaper, quicker, easier, socially considerate? It's prudent financial management, which I'll talk about a bit later. Reduces the court backlog, it increases leverage for your client, is in compliance with your obligations and the family law rules, provides greater certainty to your client, and reduces conflict, or one element of conflict amongst a bigger series of conflicts. So what I'm starting to see in other states, and so we have law firm relationships everywhere except Northern Territory now, and we have active loans across the country except for Northern Territory. What I'm starting to see elsewhere, I'm not seeing any reported decisions on this, but I know from feedback from lawyers who we have relationships with, is that they are starting to run the argument on equitable grounds that where one party has free, I use that in inverted commas, but free access to money either through income or through access to matrimonial resources, savings account or otherwise, or generally speaking, the income. And two, the other party is left with little option but to incur costs through us, through interest, to access the same amount of money to be in the same position as their spouse, simply to pay for legal representation. Then the cost component of the loan, not that which is used for legal fees, but the interest and the costs associated with it, be a joint debt of the parties, and they run that on equitable grounds. Particularly so if it saves both sides the expense of running the interim application. And ethically, the principles of the Family Law Act are that all resources are joint until determined under Section 79. And if you act for the disadvantaged party, why is it okay for the other side to have free access to joint resources, even if it's income, while your client does not? And why should your client incur a cost in interest to access the same rights that the other side is freely enjoying? And so these are some of the equitable issues that are being raised at the moment. Love to see some decisions on it. Generally, it gets negotiated away in one shape or form, but the principles of equity and the principles of fairness on this topic are certainly starting to take hold in jurisdictions elsewhere. It may even be in lawyers' interests as well, not that Attorney General's commentary is always that well received within the profession, and he has different views to a lot of people around the reform. But the highlighted section down below where it talks about family lawyers could be hit with personal cost orders if they fail to help resolve disputes quickly, inexpensively and efficiently. Whether those laws pass or not, I certainly would guarantee quite confidently that over time, as our population ages, the drain on the healthcare system with an ageing population grows, as our income falls nationally, as less workers are in the workforce, there will be a squeeze on public funds, no doubt about it. There will be increased pressure on the court system and all public departments for that matter, education and housing and main roads, for example. They're all going to feel squeezes, and there's going to be an increased obligation on solicitors to look at more ways to resolve matters without incurring costs, particularly through the court system. And whether or not lawyers are hit with personal cost orders, I don't know how they'd ever establish that as a bar to say someone exceeded a matter and ran it unnecessarily expensively so, and therefore deserves a cost order against them. I'm not sure how they'd ever establish that. And the issue around focusing on resolving disputes quickly and efficiently will not go away. Other considerations for lawyers, I've had some lawyers say to me before, we don't need you, our clients come up with the money somehow, to which my response is, well, we are just one of those somehows. People borrow from mum and dad, people ask the other side nicely or through court process, they might beg, borrow, steal from family and friends, they can borrow from us. So we are just one way in which people come up with funds to pay their invoices. An interesting case on taking loans from parents. This case of Roundtree was a commercial one. It wasn't a family law one, but the implications are certainly relevant to family law principles in that it was discussing whether something was a gift versus a loan. We know lots of family law clients run the argument that money needs to be paid back to my parents. It's a debt of the pool and the pool comes down. The other side says, no, that's not a debt. It's not true. The pool should be higher accordingly. So there's a dispute over debts versus gifts from parents, or loans from parents. Roundtree discussed the need around you need to have a genuine repayment obligation to incur a debt, otherwise it is just a gift. You need written contracts prior to or at the same time as the giving of money, and it needs to be on commercial terms. You need to have interest on a commercial rate and a repayment or repayment schedule. So hastily drawn agreements after the fact 5 years later as the marriage breaks down to say, oh, this is a loan from my parents, won't cut it. And complications are for clients if money from parents is not a loan. And what is it? Is it a gift? Is it a resource? Does it form part of the pool? It can make things messy. And so certainly borrowing externally through us as opposed to muddying the waters from borrowing from parents without the need to pay for a separate commercial loan contract drawn up between you and your parents, or say your client and your parents. Through us keeps it simpler, cleaner, protects family money, particularly if grandparents are of considerable means, and certainly makes things safer as well. So that's another practical consideration, not with respect to running interim applications, but it is a practical consideration when you're talking to your clients about their options, how they may or may not pay for fees, and the benefits of borrowing through us, or otherwise for that matter, that exists there that didn't exist before. So this is me trying to raise the awareness levels. It's certainly not me saying you must push every client through a loan. It's certainly not the case at all, because not every matter is suitable for one, nor does everyone need one. But it's more to arm you as lawyers with more options and more intelligent conversations with your clients around what their options are and what the pros and cons are of any particular course of action. Other considerations as practitioners are that if you're not carrying fees, there is an inherent conflict of interest that sits below the surface that may one day come into conflict between the advice that you are to give your clients around what they should or should not do at mediation, for example, versus your inherent interest to be paid. There's no waiver of privilege through our process. The dominant purpose of our loan is for legal advice, and it's covered by litigation funding privilege. And sections 118 and 119 of the Evidence Act are legal advice or legal proceedings. The dominant purpose of something is for legal advice or proceedings. It's covered by privilege, legal professional privilege. If your clients, if our file application is ever subpoenaed, it's your client's privilege to assert, and we'll just follow instructions that clients and lawyers give us in that regard. So far, on the second bullet point, there's nothing to learn from a subpoena. I'm happy to discuss more on that point later, but we have been subpoenaed, and so far every client has said comply, because there's nothing privileged or confidential in the application form that the other side will learn that they don't already know. And I'll explain why that is very different to our predecessors. Our predecessors 10 years ago lent to the prospects of success. They gave counsel's advice. They said, "This, we've got a great argument. This is what we're seeking. Here's our position." And they essentially were litigation funders supporting an argument, hopeful for success. We run very differently to that. We run on the basis that we fail. We lend to failure. So we already lend to the other side's position, which is the worst case outcome for your client. And therefore, the application is largely made on the basis that here is the position I'm seeking. No advice, no opinion. It's just simply what you set forth in your mediation statement, what you set forth in the initiating application with respect to the pool and the division of it. And then what does the other side say the pool is, and what does the other side say the Section 79 division should be. At a high level, no argument, no specifics, just simply we're seeking 70-30, other side seeking 50-50. I lend on the basis that your client's unsuccessful and gets 50% of the pool, not 70% as sought. And so if the other side did subpoena the file, the information in there is that your client's seeking 70% and the other side seeking 50%, both positions that everybody knows and is openly disclosed already. And there's no advice, there's no counsel's opinion, there's nothing confidential from you to the client that would be revealed in the subpoena, because I don't ask for opinions and advice. I just ask for the argument. If client transfers high cost debt to low cost debt, then it's good financial management for the client and the maintenance of the pool. We do all our personal payments through our process, and so lots of clients take that money, might be $10,000, $20,000 for example, and pay off the high cost credit card at 22% interest rate that's really hurting them, or they pay back mum and dad who lent them some money at the beginning to get the file started, or whatever it might be. So we have lots of people transferring high cost loans to low cost in us, being low cost in the process. I did publish on LinkedIn recently an article on how legal loan could be in a client's best interest, and I raised 10 points in there. Some of those things I've already discussed in the last 15 minutes, but certainly welcome for you to look me up on LinkedIn and connect, and then you'll see some articles that I've written in the past, one in which is this one, how loans can be in clients' best interest. And the reason why I've published that and written it is because it's an awareness thing. It's because lawyers, as I meet with them around the country, are influenced by predecessor funders, that is, and have a perception that's not quite right about the service we provide and how we help clients. And they're not sure if talking to clients about us is actually a good thing for them to do. They're not sure around their lawyer's obligations, and in particular, am I sending my client, who I'm obligated to look after the best interests, to a lender? Are they going to do the right thing by them? And they're not sure. So this article there is about giving you as a lawyer 10 reasons why it may be a good thing for your client, beyond the obvious, which is just simply paying fees. And I have a couple of other articles on LinkedIn as well, and I will continue to publish over time. Checklists, I'll publish practice management tips for practice managers within firms. I've got a general purpose article on LinkedIn as well around how we work at a high level, and otherwise as well. So I might stop there for the time being. I've said a lot so far, but does anyone have any questions at this moment? Do you have one that you might have thought of?
Well, I have a question.
Sure.
What I was thinking is, well, initially, one of the first things that I thought is something that I would see problematic with this is that when someone gets a partial property distribution, it's added back into the pool available for division, so it makes up the pool. It's generally already received as part of their entitlement, but it makes up the pool. The difference with this is that the general principle is that when you borrow money to pay for legal fees, it's not included in the pool. So it's $100,000 that rather than the parties are jointly responsible for as part of the pool, it's excluded completely, and it's one person's sole responsibility. And I wonder if that's something that has been looked at or addressed previously in your matters with court proceedings.
No, not that I'm aware of. I mean, I don't get involved in matters. I don't dictate settlement terms or tell solicitors or barristers how to run their files. So I don't know the ins and outs always. But I suppose at a high level, if a part property application was made, or an order was made, then the pool goes down by 100,000 at that moment in time to then gets added back, but it is transferred from one side to the other, and they then spend it on fees, and then it's notionally added back. And so when it does come to the settlement at a later point in time, it's there in kind, but not in practical terms. The loan for us, so that client still bears responsibility for their own costs. Through us as a loan, the legal fee component is always the client's obligation to pay. No one ever disputes that. If someone borrowed 100,000 from us and paid legal fees for it, that the other side wears any responsibility towards that aspect. It's only the interest component on top that law firms are starting to say should be a joint debt. Am I answering your question, or have I missed the point around it being added back or not, and what might the issue be?
Well, I think that well, it's not particularly an issue. It's just, I think, something that would have to be considered, that this $100,000 is not going to be a joint debt, whereas if you have a partial property settlement, although that one party is responsible for it, it's still in the pool as a joint debt. So I think that's just something that worth considering.
Yep.
Yeah, but it obviously comes down to the cost of running the application as well. Because if you're running an application, are you going to spend more on that than you would in your cost of paying back the loan?
Yeah, indeed.
Yeah.
And you know, the pressure on council, for example, to defer fees until the decision's made, which might take 3 months, and it's those practical considerations that everyone weighs up in each instance around how do we move it forward, how do we manage payments, tactically, commercially, what's in the best interest of a client. Yeah, look, I'm always happy to share information in that respect around what we're seeing. You know, we've been around 3 years. I've been actively involved in 18 months, and bit by bit we're growing. So our exposure as the bench starts to see more and more matters where we are involved. I'm sure there'll be more and more arguments around the characterisations of things, but
it'll be interesting to see.
Yeah, indeed.
And I would hope that obviously these sorts of loans would be able to be characterised in the pool. But you know, it's interesting as well because there's this principle that you know the court doesn't want to include loans for legal fees in pools because then there's no restriction on people going out and getting $500,000 loans for their legal fees and having that included in the pool.
Yep.
You know, they want to place some sort of boundary on people doing that. So I think it's a very interesting issue.
Yeah, there's certainly like a moral hazard argument to be having around someone making a decision and then not having to bear any consequences for it.
Yes.
And so far, if someone went and borrowed X dollars, then I would be hesitant to say that anyone would ever accept that the guts of the loan itself is in the pool. It's for my legal fees and I have to wear my own costs. But the cost component of the loan, the interest on top, then that might be reserved for dispute, particularly on that equitable grounds that the other side doesn't have to pay to access money, and why do I have to pay just to have the same equal opportunity to be heard in court? It's certainly one that is growing over time. And I know commentary from the bench 10 years ago or so were critical of lenders because they were high cost. They were 22 to 25% per annum, and a lot of lawyers, I know myself included, couldn't in good conscience talk to clients and say, this is a good thing for you to do, to pay me, and at 22% per annum. And particularly if a dispute becomes protracted over 2 or 3 years, you might find that the costs of the loan become 50% on top of then the cost of legal fees and become disproportionate. I've got a slide actually on how we're very different to our predecessors, if that would be of interest to people to see. I'm happy, I don't see any questions at the moment coming through the screen, but if you think of more, by all means, let me know, and I'll try and address any questions in advance as I talk. But I have a whole bunch of appendices in the sense that slide around how we're different to predecessors. So we want to set out to be helpful and considerate party to proceedings. It's important that the legal profession accepts the service I provide, and I think being a family lawyer myself, I'm going to be one step closer to the profession accepting the service, as opposed to historically when it was run by finance people who weren't connected to family law and weren't sensitive to the issues that family lawyers and family law clients experience on a regular basis. We are regulated. We're regulated by ASIC and the National Consumer Credit Protection Act. So I said at the very beginning, we're not litigation funders. Litigation funders are a convenient term to describe us and me and what we do, but we're very different to litigation funders. I've got a slide separately on that as well. Litigation funding is not a regulated industry. There is no rules around it. There are no consumer credit protections provided to people who engage in or seek funds from a litigation funder. It's pretty much open slather under whatever contract you sign up to. We, on the other hand, are governed by exactly the same obligations and rules that the banks and any other financial institution is governed by when they lend money to people. So the whole thing around the Royal Commission, one of the things the Royal Commission, that's actually an article that I wrote, how the Royal Commission will affect family lawyers and family law clients. But one of the things around the family law, the Royal Commission, was banks not lending responsibly. being in that they give people money that they can't repay. So the overarching obligation I have in every single loan request that comes my way from a client to pay for legal fees is, am I going to burden this person with a debt that they can't repay? Yes or no? And I've got to be able to say no in every single instance to meet responsible lending obligation. It's a reverse burden. It's essentially got to prove that the loan was not irresponsible in each instance. And so the financial institutions look to income and expenses to determine whether or not a loan is responsible for somebody. I don't look to income and expenses, hence why so many stay-at-home mothers, for example, find value in our service because they don't have an income. They can't qualify for a loan through the bank, and they can't jointly draw down on the mortgage because they can't meet the additional repayments that the mortgage would come with, because the banks still need their repayments monthly or fortnightly, whatever you agreed to with the bank. So I meet responsible lending obligations by turning to the property settlement and looking very conservatively at the property settlement, looking very much at worst case. So at point 3, I'm half the cost of predecessors, around 12% per annum. I take security. Security is a good thing. All the lenders historically were unsecured. I worry about 90% of my matters are secured. I can't take security in every instance, particularly if someone's not entitled to land and has no financial contribution to land to give rise to an equitable interest. But 90% of matters across the country, we do take security, and that decreases risk. And in finance, anything, risk equals return. The more risk, the greater the return. So if I can decrease risk and do that by being conservative and taking security, I can keep my costs down at 12% per annum and not let it float up to high teens where and into 20% where the predecessors were. We proceed on a worst case basis, so we lend to failure, not hopeful for success. So if your client was running the argument that pool's $1 million and it's a 60 to 70% split in your client's favour, and the other side says no, it's only $800,000 pool because there's a debt to mum and dad that needs to be repaid of 200, so the pool's 800, not $1 million, and it's a 50-50 split, not a 70-30, then I run the basis that client gets 50% of 800,000. So 400,000 of value will come to your client on a worst case basis. If they can discharge the loan on that basis, then they can certainly discharge it on a more favourable one if any of your arguments are successful on their behalf. And that's what the other funders did not do. They all lent hopeful for success. And so they lent on the basis this client was going to get 70% of $1 million. And then there's always two sides to an argument, and naturally sometimes the arguments were not successful and the other side were successful, and the client got 50% of 800,000, and suddenly on a $400,000 loan, like for like in this analogy, they couldn't pay back the debt, and then they defaulted, and then they all got a lot of trouble, and barristers got upset because they were mid proceedings and they couldn't continue to draw down the loan, and then the NAB turned off the lines of credit. So you might have had 50 healthy loans open to family law clients, to firms, 2 or 3 went bad, and the NAB turned the line of credit off to the other 47 as well, even though they were healthy. And so that then offended so many practitioners and clients because, well, I've done nothing wrong, why is money dried up? And that's because they lent to success, and they had no cap on loan size. I saw some at $1 million plus loans to clients. Which then became disproportionately expensive when you add on 20% per annum interest and the matter goes for 3 or 4 years. You can certainly see how very quickly a loan on a big money matter disproportionately overrides any aspect of justice or fairness. So we cap our loans at 400,000 for that very reason, so that we don't ever put clients in serious financial stress, and certainly we don't expose the business or the client to default risk. We run conservatively. We don't seek a guarantee or commitment from the law firm. We don't tell you how to run your file or dictate settlement terms. Each loan is funded from separate sources of money, so one default on one loan won't jeopardise the other ones, and that's because they're all sourced individually from mums and dads and super funds and the peer-to-peer topic that I spoke about at the very beginning of the presentation. Point 11, we self-insure. So borrowers pay a little bit extra each time they take money from us, and they put that into a provision fund, and that covers defaults. So we reimburse investors defaults from a provision fund that currently has about 1.8 times our predicted default rates. So we've, to date, 100% returned to investors, principal and interest. The legal loans division that I run has had 0 defaults in its own right, so well and truly over-contributed to that provision fund, but it's there again to decrease risk, which again is a good thing because it keeps costs down for your clients should they choose to borrow from us. Cap our loans at 400,000, and the service proposition is much to the law firm as it is the borrower. So that's how we're different to predecessors. I'm wondering if people at any point in time were thinking any of those issues, or how are you different to predecessors, and why is this, from a conversation around ethics, professional responsibility, and running interim applications of part property distribution, why should we even consider talking to RateSetter and talking to clients, sending clients your way, particularly when we had experiences historically that weren't great. There are 13 reasons why we're different, and why so far I've had 0 defaults, and why I'm setting up the business very much to be still talking to you guys in 10 years' time about these things and not having gone out of business myself. Yeah, I mean, one common question I get asked all the time is, would you ever lend to both sides? And I've only ever come across it twice, and it does raise interesting ethical dilemmas. At a high level, nothing stops me. There's no fiduciary obligation one way or the other to not lend to both sides. I'm not investing or speculating in success. I'm not litigation funding an argument hoping that they win and they lose, and therefore it will be weird to fund the other side hoping that they win and the first one loses. I'm lending to failure in both instances anyway, so I'm not hoping one person loses, because I've already run the analysis that they do, for want of a better term, lose. So nothing stops me. Part of it might be perception. What do clients think that if they borrow from us to engage in legal proceedings with their ex-spouse, if we're also supporting the former spouse? So essentially right now we've taken the first in, first served approach. It's not to say that I wouldn't consider it if the circumstances were, particularly in collaborative law matters. So I've spoken to a number of the collaborative law professionals around the country, and I was at their annual general meeting a couple of weeks ago in Sydney, and certainly raised the prospect that if a collaborative law matter was being run, or two sides to a matter were certainly conciliatory and friendly enough to jointly incur something for the benefit of them both, then I'd certainly be open to exploring it. There may be a risk. I don't see any risk of inadvertent disclosure, so I'm not asking for opinions or advice anyway. So it's not like you tell me something in the matter that's confidential that you don't want the other side to know, and I inadvertently disclose it to the other side. I'm not seeking those things anyway. So that's probably an interesting one that ethically people go, well, would you do both sides? And so far, no, only just perception reasons than it is legal reasons. I can continue with how it works, but I was conscious of not wanting to speak too much about the loan service and talk more about practicalities of the process and what it means for you as practitioners, and engaging questions if you've got any. But if you want me to talk about those things, I'm really more than happy to talk about how it works, practically speaking, but I'm really also happy to continue to talk about. Yeah, there's no questions at this point. So hopefully I've answered them already, and people are deeply interested in what I'm saying. So we only do family law matters. One thing that the previous funders did historically was lend to personal injuries disputes, contested wills, family provision claims. They went into numerous endeavours. And I'm a family lawyer, I know family law, and so I'm sticking to one thing, and that's family law matters only. I am interested to know and am happy to explore estate management, estate administration. So when probate's been granted and all you need to do is simply administer the estate, and that might take 6 months for properties to sell, and lawyers want to be paid on time and people don't want to defer their fees, I'm happy to continue to explore moving into estates. But at this point in time, given that I run under credit license and have to make sure that I lend responsibly to people and don't give them something they can't repay, any aspect of litigation that's speculative, that has risk around it, such as commercial litigation, or even things like recovery applications only, or a contested will where someone wants to have a larger chunk of someone else's inheritance, where the risk is zero, is failure, or particularly cost order against them in favour of the other side, that would make me litigation funded, not a responsible lender. So at this point in time, I only see myself sitting within credit license by working solely in family law and working only with matters that have a property settlement component attached to them. Certainly can do property and parenting or property and children's matters, but it can't be a children only matter. That's for me anyway. We do have another division that just lends to people based on income, and if they want to borrow through income to pay for legal proceedings for, parenting only matter or a drink driving charge or whatever it might be, then yeah, we have lots of lawyers send their clients to the other side of one of the other divisions of RateSetter that just does normal personal loans based on create standard lending criteria, income and expenses, credit history, etc. Then people draw upon that money for those purposes. But for me, for legal finance specifically, has to have a property settlement component because that's how they discharge the loan.
So Leigh, I can see on this slide that you said the loan is repaid in full at settlement.
Yep.
Something that that's something that raises a question for me is that we don't know when settlement is going to be,
yep.
and sometimes settlement might be in 6-7 years time. Is
yep.
that something that
that's the risk we take in that essentially we're transferring, this whole process transfers risk from the firm onto us in terms of payment of fees, particularly if the law firm's deferring fees at payment at settlement and that be 4 or 5 years away, then they're paid in full through us, and we take that risk on. So we have a 2-year loan term. We've got to have a term for certainty reasons, and if the matter hasn't settled within 2 years and it's appropriate for us to roll it over, then we do, because I can't demand a payment at 2 years if the matter's still ongoing.
Sure. Yeah. So I guess that's something that clients would want to know. If at the end of that 2-year contract it hasn't settled, are you guys in a position to be able to demand repayment?
No. Look, if they reconcile and there's no more legal proceedings, and I've actually got 2 matters right now where parties have reconciled, then I technically won't even demand repayment till term. I can't. The loan is due either at settlement or loan term.
Yeah.
And if it hasn't settled at loan term, well then it continues until its settlement. So essentially, the reality is it's due at settlement, but the loan term ceiling is there to protect against matters that reconcile or cease or.
Yes, of course.
Yeah. Or they just go missing in action. Clients just sack the lawyer and go exactly right. And that's where security becomes important so that we're not forgotten about. If we're on unsecured loans and clients go rogue and don't talk to us, then at least there's security on file, which means that.
And so in terms of security arrangements, is it the sort of situation where you would say lodge a mortgage over someone's house?
Well, yeah, different states, different security regimes. Queensland's my most problematic state in that respect. Caveat is the majority source of security that we lodge. If you're on title or have a equitable interest, then absolutely we lodge caveats. They don't lapse everywhere else in Australia except for Queensland. So in Queensland, we either will take a second mortgage if they're tenants in common interest or they are sole proprietor. I'm going down the path of exploring whether or not we insist on joint tenants splitting the joint tenancy and giving us a mortgage over the tenants in common interest. Haven't insisted on it yet, but I may go down that path. And then if they aren't on title at all but have an equitable interest, then the only option I have really is a late caveat. I say late as in a 3-month lapsing caveat close to settlement time, just to make sure that they are forced to
Yes.
deal with me. There are implications around that as to whether or not a caveat causes default under the mortgage and some issues around that respect. But my end goal is funds in trust. So if I know that funds are already in trust or it's written into the court orders that the client's settlement is to be received care of trust, the lawyer's trust account, I'll waive security in that instance because I know the flow of money will go to trust, and then there will be instructions from the client to the lawyer that was given at the beginning to pay us out of trust, as the first distribution from trust.
And do you see the settlement date as the date the court orders are made?
No, the date that the transaction takes place generally. So we often get, depending on how settlement's done, whether it's in paper form and checks are handed over, or if they've moved on to PEXA with online settlements now, or it's just simply someone's doing an EFT transfer to the solicitor's bank account, then we often get paid a few days later. The dust clears, funds into the lawyer's trust account. The lawyer then says, what's the payout figure for tomorrow? We tell them, and they just do an EFT transaction back to us. So a lot of clients don't actually see the money because we pay the funds directly to the firm, and the firm pays it back to us on instructions at settlement. And if there was never enough money to discharge the loan in full at settlement, something's gone horribly wrong. And we try to avoid that, and we would rather say no, particularly if someone's going to receive their settlement in the form of super and equity in a home, and they're not going to sell the home because school's around the corner for the kids and the grandparents are around that corner, and they're not going to sell the home, and it's likely in all practicalities, super equity and bits and bobs, then we won't lend. Even though the value might be a lot of money, the house might be $1 million unencumbered, we're not going to lend in that instance. And you wouldn't carry either in that instance. And we kind of do the same analysis that law firms would do in determining whether to carry or not. And counsel would do whether, am I going to defer my fees on this or not? We pretty much run it exactly the same analysis on top of the credit obligations under National Consumer Credit Protection Act. And so sometimes law firms may choose to carry clients that we can't help with because you're not obligated as a solicitor to lend responsibly, whereas we are, which means that we have to say no sometimes to deserving people. And the law firm might say, look, that argument the other side's running is ridiculous, but I have to take the other side's argument into account, which may then mean that I'm precluded from lending because the worst case outcome is the other side successful, even though it's remote or it's ridiculous, I still have to take it into account. So there are some deserving files where I've had to say no. Hence why my approval rate's like 60%, not higher. So zero repayments during the matter. That's the whole point, right? If clients can't pay you regularly, we can't expect them to make repayments to us regularly, so we defer everything. Loans are paid once at settlement, and we can pay Grant Thornton, we can pay lawyers' fees, we can pay Ray White to value property and real estate, and then personal payments as well. So it does certainly create greater options for clients, and really what it does do is it gives me more lawyers with extra options when talking to clients. Your advice to clients when they can't pay for fees is pretty restricted. And it's not a pleasant conversation to have. All I do is present you with an extra option that you can give to your clients. And it's your clients who apply, and then we then write to you and say, I've had an application from Mrs. Smith for $50,000 or whatever it might be. And it's a line of credit, so they don't have to take it all. It's approved up to a limit, and they just draw down upon it over time to pay the fees as they go. And so whether they use it or not, they don't incur interest on things on the money they don't draw down. And so then the client will apply, and then we will then write to the lawyer asking for the lawyer case summary, which is some questions around 75.2 and 39.4 and the life of the marriage and what does the pool according to husband and wife and the balance sheet. I don't want the court docs. I just want a simple balance sheet, husband's view, wife's view, and I can see very clearly what's in dispute and what you're seeking and what the other side's seeking. And that's how we run the process. Everything's done online, and we go from there. But at the back end of these slides, there's more information, not litigation funders, costs, lending rules, the steps to the process, and also links, my phone number, my email address. So I'm happy for these slides to be sent out. People can call me at any point in time. Yep.
All right, well, I think we can all agree that this is something that is pretty new to us in Queensland, having heard some horror stories about litigation funders many years ago. So this is something that we should all be, and our clients should be really excited about. So thank you so much, Leigh, for coming to speak with us today. If anyone has any questions, we haven't had any here today, but you can get in contact with Leigh directly through the slides, which we'll send out after this. If you wanted to discuss more about this option for your firm and your clients directly, I think that Leigh would be very open to that. So thank you so much for joining us today, and have a lovely afternoon.
Thank you.